Jury selection has officially begun in the trial of Christopher Schurr. The former GRPD officer is charged with second-degree murder in the shooting death of Patrick Lioya. It happened 3 years ago during a traffic stop that went bad after Lioya did not listen to commands. As the jury is selected, we have a lawyer joining us in studio to help us walk through what the selection process will look like. Andrew Rodenhouse of Rodenhouse Law here in GR joins us now. Let's start with how the jury members are seated here. Of course, we have a pool of about 200 potential jurors. That gets weeded out to about 12 for the start of the trial, again, starting on Monday. So I guess, how do they get to that point? What does the jury selection process look like in your opinion, in your view?
Well, good morning, and thank you for having me. So jury selection in a homicide trial requires seating of 14 jurors. At the end of the trial, 2 jurors will be randomly selected to be alternates. The other 12 will sit on the jury and render the verdict. At this point in time, they've brought in about 200 jurors to be on the veneer. They've already started the selection process. They started it yesterday with filling out forms and having the judge instruct them on what they're looking for. And I think the judge was also trying to find out if there was any conflicts with time, because the jury has to sit for at least an entire week.
Right.
So if people have already pre-scheduled vacation plans or work plans, then they'll be let go out of that jury pool. They have to select the entire pool. They have to select all the jurors for all 14 out of that one pool. If they don't get all the jurors they need out of that pool, they actually have to bring in another pool and start over. So everybody has a vested interest in finding the 14 jurors out of the 200 to sit on the jury.
Okay, so if they, let's say, select 13, do they have to start over? They can't get that 14th juror. Do they have to start over? Is that what I'm hearing you say
That's
here?
That's what has to happen. They have to then dismiss everybody, bring in another 200 people. So even the defense has a vested interest in trying to select 14 people out of the 200. And each side gets, in a homicide trial, each side gets what's known as 12 preemptory challenges, meaning they can challenge and dismiss a juror for any reason whatsoever.
With no questions asked.
With no question. Well, the exception is the prosecutor can't use their preemptory challenges to target like a specific group of people or type of people. And if the defense thinks they're doing that, then there's what's known as a Batson challenge. It's from a case, Kentucky versus Batson, where the prosecution has to say why they're dismissing a particular juror if they're in some type of immutable class of people. The defense, on the other hand, can dismiss a jury just for even the way they look. I dismissed one juror one time because I didn't like her shoes, and her shoes were telling me something about her that I didn't want that type of person on a jury. So every little detail gets examined by the attorneys.
Wow. So really this is a full locked-in process on both sides. Can you kind of explain, because again, we have 200 jurors. It's a very finicky process to get those 14 people sat for the jury. What sort of questions are maybe the attorneys on both sides, or maybe the judge, asking in this case to help seat those jurors? Again, this is an objective process here because we don't know what's going on in that jury selection room right now. But what would you imagine those questions are looking like for this trial?
Well, for this trial, my understanding is that the potential jurors filled out forms, just wanting to get basic information. The first thing I want to know when I'm selecting a jury is, what do you do for a living? Like what's your work? What's your educational background? What's your family life like? Are you married? Are you single? Do you have kids? What do your kids do? Are you old? Are you retired? And so that gives you a lot of information about a person, and then you can use that information to drill down deeper into what you're trying to find as a juror that's gonna not have a bias. At the end of the day, that's what both parties want, is somebody that can sit without a bias, listen to the facts and listen to the judge, and take the law from the judge as the judge gives it in final jury instructions.
When you're maybe a prosecutor in this case, or maybe you're a part of the defense team here, do you have to kind of get into the head of the other side to kind of think about what they're thinking a perfect juror in their mind might be to kind of help with that unbiased process? Or what are the attorneys thinking in this process when they're trying to select jury members?
Well, it's going to be difficult to look into the mind of what they're specifically thinking, because I'm not part of either team. I can tell you what, if I was on looking for a juror, I would want a juror that understands, if I was on the defense team, understands the lawful use of self-defense and what that looks like. Maybe somebody who's trained in lawful self-defense, maybe a CPL holder or somebody who is familiar with tasers or stun guns. The prosecution, I think, is looking for people who aren't going to be biased against the alleged victim, Mr. Loyola. And so I think that's going to be the overriding concern of the parties as they select jurors.
When we're talking about a case this big and the national attention that it's gotten, there is probably a good chance that some of these jurors have possibly watched news coverage of this when it happened, and of course the fallout from that. And of course, all of the coverage across the country that this has gotten. How does a court control having jurors be influenced by that? Can they, or is there a way that they do help, whittle those down to some unbiased jurors here?
Well, that's part of the selection process. So it's going to be nearly impossible to have a juror who hasn't heard anything about the case. What you want to find out is, have they already come to an opinion on it based on what they've heard in the media? And so what you're looking for is a juror who might say, the juror might say, I've heard of the case, I'm not real familiar with it, I haven't really followed it, I'm open-minded, I haven't made up any decision one way or the other, versus a potential juror who might say, I've been following the case closely and I think that this is my opinion on it and I don't think anyone could ever sway me from my opinion. Well, then at that point in time, you use what is known as a for-cause challenge, and there's an unlimited number of for-cause challenges you can have, and so that's how you end up getting through potentially all 200 jurors, is having a lot of people have opinions on it. And then you can challenge that juror for cause, and oftentimes the judge will dismiss that juror, or the judge might inquire further and ask, well, what is your opinion? How did you form that opinion? If you heard from other witnesses, would you be willing to change your opinion? And delving in further. I've had cases where the judge, in fact, I was thinking as I was waiting to come on your show, I had a case once where a juror said that, no, they absolutely had their own opinion, and the judge asked, if I ordered you to have no opinion, would you be able to do that? And she said yes. And so I ended up having to use a preemptory challenge on her because the judge said that she could follow the law.
Well, and your point there being, it's not easy to flip that sort of quote-unquote bias off.
Correct.
And so that would be an instance where you would use that challenge.
Exactly. Okay. But
Okay.
you only get 12 of them. And so if you're using them on jurors that have biases that should have been dismissed for cause, and you're not using them for another reason that you might want to dismiss a juror.
So there really is kind of a strategy here. If you're on the defense side, what sort of strategy are you kind of looking for here as you pick a juror?
Well, like I said, I think it would be important to have jurors who understand lethal self-defense, potential jurors who understand that if somebody is threatening your life, that they would be okay with taking a life if somebody was threatening your life or a life of a family member. And I've tried a lot of self-defense cases, and I'm always shocked by how many people say that if somebody broke into my home and was threatening to kill me, I wouldn't be able to use lethal force. And so they just, for moral reasons, could never contemplate that. And so those are people that maybe wouldn't be dismissed for cause you would have to use a preemptory challenge on.
Interesting. So it really is kind of a strategy once you get into the thick of it. And especially with there being 200 people within the pool here, you got to kind of pick and choose where you place those challenges at if the people that you're looking for aren't getting weeded out. Let's talk about the prosecutory side here. What are those people kind of looking for in maybe a potential juror? What would you think?
I think they're looking for a juror that, first of all, is going to give everybody a fair trial. Contrary to what a lot of people think about prosecutors in general, mostly they're seeking just justice. And what does justice mean? Justice means that a person has a fair trial, and it comes to a verdict, and a verdict is rendered. And they're not necessarily looking to win at all costs. What they're looking to do is uphold the standard of justice. And if it means that they have a juror that has a bias in their favor, they're not going to try to fight for that juror other than to have the defense use a preemptory challenge. So I don't think that I've never really come across a case where a prosecutor was trying to put a hand on a scale of justice in favor of the state against the defendant. They were just trying to do what prosecutors are sworn to do, which is to seek justice.
Let's talk about some other things that might get you disqualified from a jury. Aside from any biases that you might have for or against the case, what are some other factors that the judge or maybe prosecutors or defense attorneys are looking at here that might get somebody disqualified from a case, just in the grand scheme of things?
Prior criminal history is a big one. Does someone have a prior criminal history? Has somebody ever been a victim of a crime? Does somebody have a family member who's been a victim of a crime similar to the crime that's on trial? In sexual assault cases, people will have deep feelings about those, and they'll know a family member or they themselves will have been a victim, and at that point in time, the judge can dismiss them, and you really don't want those kind of people on that kind of a jury. And you got to remember, there's plenty of other types of cases that you can sit on as a juror that don't include homicide or a serious assault.
I want to ask you, let's say that we end up not seating this round of 200 jury pool people, if you will. What happens next in that process? Do they have to recall everyone back very quickly, or how does that all work?
They have to bring in another 200.
And do they have that ready to go, or is that something?
I don't know.
Okay.
I don't know. My strong suspicion is, I heard reports from the judge that the judge is confident we're going to have a jury seated this week.
Okay.
I've dealt with Judge Mims. I've tried a number of cases with her. She's a very competent judge, and so if she's saying she's confident, then I'm confident that it's going to happen. I think that 200 would be sufficient.
Yeah.
But you never know. It's an outside chance.
When we're talking about jury selection and the trial as a whole, is it just as important to get jury selection right as it is to come out on the other end of this trial?
Jury selection can be the most significant part of the case. To get the right people on the jury for your particular point of view. For the defense, in this case, again, you're going to want people who are familiar with what lawful self-defense is, because it's not something that is normal in society. There's not a lot of people out there that truly understand it. And that's why they have experts. And so I would anticipate experts from both sides during trial this week. But as far as jury selection goes, getting open-minded people who can listen to both sides, and then at the end of the day, have the ability to come to a verdict and make a decision. One thing that you don't want is a person on the jury who can't make a decision and then just goes with the whims of the other people. And so it's important to weed those people out. And again, that's just part of the process in selecting the jury.
I have two more questions for you. One, the judge was confident, you said, that we would get a jury seated. Do you think we're confident in getting a jury seated? And if so, how long do you think that process will take this week?
I think it's over this week. I think that they get a jury seated. And if I had to bet money, I would say probably Thursday is when they have the jury seated.
Yeah, again, we're talking about...
That's my best guess. I'm just basing it on, I've tried lots and lots of cases, and I've tried some pretty big media cases too, and I think that they've done a pretty good job of getting this information out already.
Yeah.
And so the attorneys will have time to review it in written form and have a good idea when they start selection this morning. The people who are initially seated for voir dire, as we call it, they already have a lot of information from them.
Yeah.
So I'm pretty confident that they'll get it done this week. And again, if I had to bet my money, it would be on Thursday.
Well, Thursday, that gives them enough time to seat, whittle that number down from 200 to 14, again, 12 actual jurors with those two alternates. Last question here is, I guess, what do you want the people at home watching this interview right now to take away from the jury selection process as we head into trial next week?
I get emotional every time I hear a judge say this. and that the duty of sitting on a jury is the only duty that our country insists upon its citizens doing. Everything else is a right that we get from our country. Jury duty is the only duty we have to our country. And jury duty, sitting as a juror on a jury, is the thing that stands between our civil society and tyranny. And I had a juror actually say that to me once, and I said, well, what do you mean by that? And he says, well, it's the government that's trying the case, and it's the citizens who are sitting in judgment of a fellow citizen. And it's the only way that we can have a civil society is if we have citizens willing to sit in judgment on a fellow citizen and hold the government to their burden. And if the government doesn't meet their burden, then the presumption is that the person is innocent and they must be acquitted. And I find that deeply beautiful and emotional and patriotic. And so that would be my one takeaway, is that these jurors are doing their patriotic duty.
All right, and well said. We're going to have to leave it there,
Okay,
Mr.
well, thank you for
Rodenhouse.
having me.
We appreciate your time, and of course, we will be checking in with you a lot over the course of the next several weeks
I look forward
as
to it.
The trial of Christopher Schurr gets underway.